I'm Scott Loughlin. This is the Data Chronicles, and here are your data points. Today is a very special episode of the Data Chronicles. As we're recording this, it is IAPP week here in the United States. We are having the IAPP Global Summit airing this week, which means that it's a very busy week for the privacy practice here at Hogan Lovells. We have a number of client events that are ongoing, including before and during the conference. And we thought this would be a great time to record a Data Chronicles episode. And so really appreciate everybody joining. Today, we are discussing the EU AI Act. It's coming and it's big. It's the first attempt by humans to place a comprehensive legal structure around artificial intelligence, which itself is so broad that is difficult to define. It's also very likely to be a predictor of things to come. For that, let's just look back 10 years ago. In 2014, the EU, while it had the directive, did not really have a uniform, comprehensive data privacy law. Frankly, neither did the United States. 2 years later, we have GDPR-inspired laws around the world, including in California. And 4 years after that, we have a number of laws worldwide that find in their cores the GDPR, including 15 states in the United States. So is it a stretch to think that the EU AI Act will follow a similar path? I don't think so. As a result, it's time now to dive into the EU AI Act, not only to understand what will be required in the immediate future, but also to understand what life will look like for the next several decades under similar laws popping up in the United States and around the world. To discuss, I've invited my co-chair of the Hogan Lovells privacy practice, Eduardo Ustaran, to the podcast. Eduardo is well known wherever he goes in privacy and now AI circles, and he is one of the world's leading authorities on EU, UK data protection and AI regulation. Eduardo, welcome to the podcast.
Thank you very much.
So we are, for those who are watching us on YouTube, you'll see us, that's a different format than we normally do it. We're actually doing this in person. And I think this is well timed because you are speaking at IAPP Global Summit on this very topic as part of a set of presentations around and trying to understand the EU AI Act. So really appreciate your sharing your insights, not only with the audience at IAPP, but with our Data Chronicles podcast.
My pleasure.
So let's start maybe with an easy one, Eduardo. According to the EU AI Act, what is artificial intelligence?
Excellent question. Well, artificial intelligence or an artificial intelligence system is actually defined by the AI Act. So that's a good start. And it's defined as a system, if we could call it software if you wanted to, that displays some kind of autonomy and is able to adapt itself in order to infer some kind of outputs. And when we talk about outputs, we're talking about, for example, predictions, content, recommendations, decisions. So when you try to interpret that, it's essentially technology, but that is it goes a little bit farther than technology and software as we know it today, because it's technology that, again, as the word suggests, artificially thinks a bit like a human, and therefore is able to reach some or produce some outcomes and reach some decisions. So that's what it is about. But if we take a step back in terms of the background that you were talking about and what the EU is trying to do with this, because we are seeing the proliferation of this type of systems, of this type of technology throughout the world, and is taking over the world in the nicest possible way, the EU always thinking ahead, thinking about how to regulate and how to ensure that technology serves humans. In something like this, where there is a degree of at least perceived risk that technology could overcome the way humans think, the EU is trying to be very specific about the rights, the protections, and the ability of humans to control the technology. So it's mainly European approach to AI regulation is mainly about humans being at the center of what this technology is about, so that effectively the outcomes and these outcomes that the technology is going to produce benefit humans.
I mean, the part that I struggle with, and I think, frankly, regulators and legislatures struggle with, is trying to understand perhaps what's not artificial intelligence nowadays. Because when I speak about this topic, I like to say and try to say, like, artificial intelligence is not new, right? We've been dealing with and using artificial intelligence for 20 plus years. It's gotten much better. It's gotten much more advanced, but frankly, it's gotten much more pervasive, right? Since I woke up this morning, every time from my alarm clock ringing on my phone to when I put on my watch, my smartwatch, or when I got into my car with using GPS, or when is it that I was, typing an email and I had spell check come up. All of these things have artificial intelligence around them. And frankly, they have been had artificial intelligence around them for some period of time. So my question really is, if it's all around us and it's in places where we have long since as a society been comfortable, presumably, with doing it, what has changed and how is it that we say we don't have these obligations?
Sure. I think we have reached some kind of tipping point in the evolution of AI. I think all technologies evolve, and I've been around for a while to see how the world was before the internet and how the internet took technology further. And then we saw cloud computing, for example, and cloud computing became computing. And I think what we're seeing is AI, in the way you're describing, becoming the new way of doing computing. I think the difference now is that, of course, we've seen over the past years or couple of years how this technology is so powerful and have such a deep impact on our lives, on democracies, on the ways we prosper in life, that regulators feel that they need to do something about it now. And I think that is what has triggered that tipping point to start regulating it in this much more perhaps aggressive, or at least much more active way.
So I want to get to what does that mean from a competitive perspective, because as you may guess, is right, different countries, different cultures see these issues very differently. But before we get there, let's just kind of make sure we understand what the framework looks like for the EU AI Act. I think much has been said around that this is a risk-based approach, and it's important to categorize different technologies, different uses of those technologies based on risks, and then the associated legal obligations would fall out of those categorizations. From your perspective, what's the best way of trying to understand this structure and, giving the audience a perspective about where it is they would need to, how they would need to comply with these obligations?
So you refer to the risk-based approach. And I think when you look at the AI Act in particular, the risk-based approach is everything. It's what, in a sense, defines the AI Act. And if we thought that the GDPR was also risk-based, which is true, it is so much simpler to look at the risk-based approach of the GDPR compared to the AI Act. And the reason is this. When you look at how the AI Act defines and describes the different types of AIs that may exist, it gives you this classification. It starts by saying some of them are just so risky, they are just so potentially harmful that they should be prohibited. So that is the prohibited AI. And for example, for those who are familiar with the movie Minority Report and the idea that the computer can predict whether you're going to be a criminal or whether you're going to commit a crime, that is prohibited. So that type of very sort of intrusive type of AI. Then you move further down the line to what is probably the core of what the AI Act is all about, which is the high risk AI. So it is still very risky, not as damaging to individuals, but for example, systems that are listed in one of the annexes of the Act, but that are used to make decisions about people's employment, for example. Or imagine that your promotion is decided instead of by other partners or our community people, is decided by a machine. So that is the high risk AI. Then you have some more lenient type of AI, which is what we could call the transparency risk AI. And by that, what the law means is that there are some types of AI that are used every day, but that we don't quite necessarily know that we are dealing with AI. And therefore, what the law requires is for whoever is deploying that system to be transparent. The most obvious example is a chat box, for example. If you're talking with a robot, maybe today you can tell it's a robot, but in the future, the system will have to tell you, I am a robot. And then the AI Act also regulates something which is a little bit outside this categorization of systems, and is what is called general purpose AI models. And these are models that are, as the word suggests, can be used for all kinds of general purposes and then can be integrated for completely different purposes. And within that type of AI models, then there is a subset called the general purpose AI with systematic risk, which are the ones that are so much more powerful that have an additional level of risk. And then you have the rest of AI. So if you think about the classification I've just gone through, there are effectively 6 different types of AI that I've mentioned, from the prohibited ones to the most innocuous type. And if you look at it from the point of view of the GDPR, where you basically have non-personal data, personal data, or special category data, the most is 3. Here we have 6. And that is the complexity and how the politicians, I guess, the policymakers have seen the risk that each of these type of systems or types of technologies attract.
And so, I'm a visual person. And so as you're describing this, I'm kind of almost seeing colors kind of pop up in my mind, starting from the prohibited, the Minority Report example, it being red, right? Can't do it.
You can't do it.
All the way to the other side, we have green, listen, we're not going to get in your way. You do you. Everybody goes on with their lives. And then all between those things, we have, every shade of yellow. And I guess maybe what's red and yellow, I think orange, my 6th grade art teacher would be happy if I remembered that. And so you then find yourself within this spectrum. And what I also then understand is that you then need to say, all right, we're going to be using this type of artificial intelligence. We need to find ourselves on the spectrum, red to green, probably somewhere between. And then our legal obligations will fall out of which one of those categories we fall in. So maybe that kind of begs the question. Risk is a funny thing, right? Because we can all identify that there is risk, but typically we can't agree on the levels of risk. My approach to life may be more risk adverse than yours. You may be more risk tolerant than me. That is just the 2 of us. If we have 100 people in the room, they're probably going to be at least 70 to 80 different views on risk. So how do an organization then think about where they fall on that spectrum? Is it left to their discretion? Are they subject to second guessing? Is there some type of additional things that they need to be considering as they figure out which shade of yellow they are dealing with?
So you need to obviously understand very, very well what kind of AI system or model you are talking about in your particular use case, so that then you can say, oh, this belongs to the yellow category, or to the orange, or to the red, or to the whatever. And therefore, the act itself is quite prescriptive in terms of what you need to do for each level of risk. But there is another dimension that we need to take into account, which is where you fit in that spectrum in terms of your role in relation to the AI. And the AI Act has 2 main players here. What the AI Act calls the provider, which is essentially the developer of the technology, and what the AI Act calls the deployer, which is the user. We could call it the corporate user rather than the end user, the individual user. So those 2, and there are other categories like importer and distributor, but if you just focus on the main 2, which are the provider and the deployer, depending on which role you play in relation to these types of AI, different obligations will apply. So you need to do that matrix, which is not just by colors, but also by roles in terms of understanding what obligations will apply to you and how to comply with that.
I mean, I agree with that. And that seems like intuitively that would make sense. But what I think it ignores, and maybe where I think people get frustrated, is that the technology here is really difficult to understand, right? And in some ways, it's very hard for people to understand not only the technology that they're using, but to get to the level that I think, is maybe expected, is that users will have an information gap compared to the developers or the producers of those technologies. If you're putting the obligation on the users to be able to define where they fall within inside of this, there is going to be obligations that they themselves are not well equipped to be able to address, because they probably haven't done all of the testing, all of the training, all of the quality assurance and human oversight and accuracy, all of the various themes that come out of AI regulation. They're not really in position to know or even to do those things. They're wholly dependent on the developers to have done those things. And so that, I think, equates to the users having to push obligations back to the developers, asking the developers how they have met these obligations. And now we're still at the same moment of kind of like controller processor dynamics of, the controller asking the processor, hey, how are you using my data? Now it's just the same concept, but a user asking the developer, hey, how did you develop this AI and my uses of it? Where am I going to fall in the spectrum?
Well, the interesting thing here is that the AI Act does that for you, in the sense that you mentioned the controller and processor roles. And when we look at that from the point of view of European data protection, the controller is the one calling the shots, and most of the obligations of the GDPR fall onto the controller. And the processor has some obligations, but they mostly derive from the obligations that are imposed contractually by the controller. The AI Act turns that on its head, and it is the developer, so the provider of the technology, that is the one that is calling the shots in terms of the development of that technology. And therefore, the obligations, particularly in relation to the two main types of all those types of systems, the high-risk AI and the general purpose AI, the bulk of the obligations fall onto that provider, which will then be tasked with ensuring that they have undertaken the right steps, that they have the right mechanisms in place to develop that AI in compliance with the Act, and then they tell the deployers to use it in accordance with those parameters. So most of the obligations of the AI Act will fall onto those developers, and some of them will fall onto the deployers.
But it also then is the case that the users will define many cases the use cases of these, right? Because they are going to have new ways of deploying this compared to the producers of the technology. So let's just say, for example, you use the pre-crime, minority report example. I get it, solid red. We can't use AI to detect crime before it has been committed. But if we look at AI technologies that identify whether somebody is going to engage in a potential criminal activity in order to prevent that criminal activity from happening, is that red? Is that yellow? Is that, green? Part of it is like, okay, we can't arrest the person perhaps for, having taken this, but if we use satellite imagery to identify, whether the shape of somebody's coat reveals that they have a suicide vest on, and that they're walking into the middle of Times Square, and all of a sudden, hey, we need to figure out whether this person is about to commit a terrorist action. Is that an appropriate use of AI? Because the AI is identifying the shape of that individual's person's torso and the irregularities in that person's jacket for then to be able to identify, is that identifying pre-crime? We're trying to prevent a terrorist action for sure. I don't think we're trying to arrest that person for, other than the fact that that person may result in evidence that that person is engaged in a criminal activity.
You are actually referring to one of the most controversial aspects of the AI Act, which in theory, the type of system that you are describing, that is all about predictions of crime, and particularly if biometrics are involved or facial recognition, in principle, that is red. That is a prohibited AI in Europe. You cannot use it. You can simply not put that in the market, except that in relation to very serious crimes, like, for example, terrorism, that is allowed. And there was an exemption from the prohibition that was included precisely for the reason that you are referring to, that there may be circumstances where it may be justifiable. But let's just go to something a little bit more mundane. Because, for example, we're all used to using generative AI today, whichever commercial model that you use. Generative AI, in order to provide content, could be used for something as simple as, please tell me some, or give me some recommendations for good pizza restaurants in Washington, D.C., in the area where I am tonight. Now,
Hopefully that's green.
and I can assure you that some of the systems out there will be very good at that. So that is very innocuous. And that's a still general purpose AI that is used for a very specific use case. But the same type of general purpose AI could be used to say, okay, well, now I want you to recommend to me, for example, on which of these businesses I should be investing my life savings. And in principle, the technology works in exactly the same way. If you look at all the data it's been trained with, and it will make some calculations in terms of probabilities and say, okay, well, I think you should invest in this and this and this and this. And that essentially the same functionality as the restaurant recommendation crosses the line to the high risk AI. And therefore, the deployer of that system, if you run a business which is based on that generative AI, but that it is used in order to provide those type of very life determining recommendations as opposed to which pizza you're going to eat tonight, that type of much more life-defining decision will fall into the category of high-risk AI and be subject to the requirements that apply to that category. So the use case will define the risk in a way. And that, I guess that's what the policymakers have tried to achieve with this.
But that's where I feel like the tension is being created, especially if you are trying to push specific obligations on the developers versus putting specific obligations on the users. Because the developers are coming up with technology, and maybe they only tested the technology to identify pizza recommendations. And the users say, well, listen, I don't care so much about pizza recommendations, but I would really love the latest stock tip. And the system is not tested or verified or designed for that use case. But it turns out that that is a very good use case, or at least people in the market see it as that.
Which I think that brings us perhaps to one of the practicalities of what you can and perhaps should do today in terms of starting your journey towards compliance with the AI Act, which is to determine the way in which the AI Act and the obligations within it will apply to your specific use. Because whether you are a developer or you are a deployer of the technology, and whether you are in developing general purpose AI, or you are developing already high-risk AI, or you're developing general purpose, but then your user will use it for a high-risk purpose, that will change the landscape of obligations that apply. So carrying out that exercise of saying, okay, I am in this position, I am developing, or I am somewhere in between the evolution or life cycle of the technology, and I'm going to use it for this particular purpose. Understanding that and then applying the obligations in that particular use case will be possibly the first most important step that anyone can do in order to understand what to do.
So we go through the exercise of defining the use cases. We go through the exercise of trying to identify the relevant risks. Presumably now the obligations are going to be around documenting how we came to those conclusions, and then documenting how we are mitigating any of the associated risks that come from our uses. Is that right? I mean, is this now a documentation exercise, or are there other substantive obligations that we're going to now need to bake into this process?
I think the key words are technical documentation, in the sense that we as privacy lawyers were very used to creating policies and procedures to ensure compliance with the law. Here, it's a little bit the same, but at a much more technical level, where I can see the difference is going to be that those who are responsible for compliance with the law within an organization are going to have to work very closely with those that are responsible for developing the technology or integrating the technology, so that that responsibility to create and communicate that technical information, sometimes to your customers, sometimes to regulators, sometimes to the end users, those obligations that will apply are following the specific prescriptions. And again, the act is very prescriptive as to what documentation you need to include, but that follows the way in which the technology has been developed, what data has been used, whether any copyright considerations have been taken into account, what outputs that technology is aimed to provide, and what outputs should not be used for. So that type of, again, documentation needs to be articulated, but in a very technical way.
And if I had to guess, I mean, this is not the prediction episode that you and I do at the end of every year, but if I had to guess where what's going to go, is that it's almost similar to like the TOMS list that would appear at the end of standard contractual clauses, the technical organizational measures that would appear, provide or developer written descriptions, which then say, hey, here is your list of the technical uses, all of the stuff that we've done. User, you take this, add it to your own documentation, good to go.
Absolutely. And in the same way, we're used to this crucial contractual relationship between controllers and processor under the GDPR. I think what we're going to see is a perhaps even more important contractual relationship between the providers and the deployers, because the liability that each of them will have will very much be dependent on what the other does. So if I'm a deployer, I want to make sure that the technology that I'm going to integrate in my system for all the important things that I'm going to use that technology for is safe, is legal, is ethical, and so on. And therefore, I'm going to seek those kind of warranties from the provider. But if I'm the provider, I want to make sure that my customer uses that technology in the way it was designed and not for other purposes that, if, for example, create some harm, may come back to me as the developer of that technology. So that relationship, that contractual relationship, and the ability to articulate where the obligations of the parties are is going to be absolutely crucial in ensuring compliance with the law.
I mean, that point is one I wholeheartedly agree with. And I feel as though the privacy and cybersecurity professionals, in our audience will relate to this immediately, because as you know, it is often the case that a privacy, cybersecurity, data-related concern is just going to fall back to the lawyers to then have to work out in their commercial agreements with their processors or their sub-processors or any of the other relationships that are contemplated. In other words, where the rubber hits the road is the conversation between the processor and the controller, processor and sub-processor. And that is in the type of contract as they're starting to work through these issues. And while, perhaps there's more market standards for data protection today than there was 5-10 years ago, we're now going to be in the AI space, back to use the US term, the Wild West of AI negotiations. And it's going to be left to those same individuals to have to solve for these issues as part of their relationships.
Yeah, and I think something we need to bear in mind is that even though the law defines roles, and there's a definition for what a provider is, and there's a definition for what a deployer is, real life is much more subtle than that. And from the early work we're already doing, we can see that many of our clients are both. depending on what they are doing within that life cycle of the technology. And therefore, in the same way, we have learned to see how, again, the controller processor role starts to merge sometimes, and processors are trying to do more and more with the data. In a very similar fashion, we're going to see how providers of the technology, even at the purest end of that development, are still going to be relying on those even farther down the chain, like the sub-processors that are going to be providing the tools for those providers, for those developers to develop that wonderful technology. And then the deployers, again, when they integrate the technology, I can imagine they will start fine-tuning things, they will start configuring things, and they start slipping into the shoes of the provider of the system at the same time that they are a user. So I think we need to bear that in mind, that we're not going to live in this very neat world where you fall into one category or the other.
Fascinating. So, I started the episode of giving an early prediction. Again, not the prediction episode, but I predict that the EU AI Act is going to find its way into other requirements around the world, including eventually probably at the state level here in the United States. So my question is, putting that aside, what is the jurisdictional reach of the EU AI Act when it goes into force? Does it extend only to AI developed and used in Europe, or does it have a broader application?
Yeah, so I think the best way to understand that is that, of course, European law in this particular case is aimed at ensuring that the European Union functions in this very harmonized way, and that European Union people are the ones that are protected. And therefore, the scope of the territorial application of the Act is all about whether, if you are a provider of the system, you are making that available in the EU, or if you are a deployer of the system, you are deploying it in the EU. Or even if you are outside entirely, the outcomes of that technology affects people in the EU, because it's all about protecting people in the EU. So I would say that in the same way, again, using the similarities with the GDPR, we've learned to live with this idea of the targeting criterion of the territorial applicability. That is, if you are targeting the European market, the law will apply. Here is exactly the same. If you may be based in Silicon Valley or in India or in China, but if you are targeting the European technology, the European market with your technology, then the law will apply.
So when you say, is it the targeting trigger, or you use the word effect? Because, for example, suppose I'm using artificial intelligence to identify, I don't know, health correlations in my population in Alabama, to understand if you eat this type of fast food, it's going to result in this type of health concern. Obviously, that's knowledge that may be having generated through artificial intelligence, which would have a much wider impact and can easily then be delivered and used within populations in France and Spain and elsewhere in the EU. Does the fact that I develop something for one audience and then now use it for a different audience now trigger the EU AI Act?
Absolutely. So it could well be that the data that was used to train the model, for example, was not European data at all. It may have all been based in, Alabama's data. But then if you are applying that technology for use in the EU, and patients somewhere in the EU are going to be able to, let's say, benefit from that technology, all the obligations of the law will effectively apply to the way in which the technology was developed.
So in that example, if I'm developing something which could have a larger impact, and obviously I would love for it to have a larger impact for some of these technologies, I have to be planning for the eventual rollout within the EU today, even if the EU has no direct connection to the technology and the research that's being done right now.
Yeah, but I think that if we're talking of technology, that is meant to benefit humans all over the world, and that is technology that can move through data flows very, very quickly, instantaneously throughout the world, the chances are that unless you are a very, very domestic type of business, you're going to reach that wider audience. And therefore, the implication is that the law will apply. Whether it is enforced or to what extent, again, developer of AI technology in Alabama is going to be a priority for the European regulators is a different matter. But ultimately, in terms of the question of does the law apply, absolutely yes.
So maybe my second to last question is, if I'm thinking about the policy here, it's really difficult to figure out where is the right balance. There is obviously, sci-fi movies forever have been articulating kind of the dangers of artificial intelligence, and that's gotten a lot of people who are scared and feared about it. At the same time, we are developing technology around the world, not just within the EU, not just within the United States, not just within any of these other countries. And as I started earlier, like the societal views on where the balance is between risk and technology, government, democracy, authoritarian governments, like that's all differences in the way that the human populations work. So if we're going to, put these boundaries, either, maybe some of the things that are red, we're not going to allow, but all the other stuff you could describe as at least more costs having to associate with the development of and uses of artificial intelligence, or maybe another way of describing is more friction, more resistance being able to do it, such that you are giving different competitors an advantage for those who don't have to deal with all of this versus those who end up having to deal with it. One is cheaper than the other. And so quickly you can start seeing, where there will be opportunities for developers in some territories versus others. How is the EU thinking about that? And I know, from your perspective, living in the UK, I think the UK is actually thinking about it perhaps even slightly differently.
Well, I know how the EU is thinking about this, because what the EU is trying to do here is to benefit from the best of all possible worlds. So the EU is still aiming to have AI technology being rolled out and benefiting people in the EU. There is no one involved in the AI Act who would tell you otherwise. The question is that for them is that they are looking at it in the sense that in order for that technology to be truly beneficial, it needs to meet all these requirements. So ultimately, that is the win-win, because the technology will work, the technology will be effective, the technology will be safer thanks to this law. That is the thinking. Whether the law is too strict, whether the law is not pragmatic enough, that will be seen over time. I think we are used to looking at the EU as being perhaps at the most dogmatic side of digital regulation, if we have to be fair about that. But that is because the policy that is inspiring that law is precisely for pursuing that particular aim of protecting individuals. So they err on the side of caution and the law becomes a bit more dogmatic. You could be at the opposite end and say, let's not regulate this at all. Let's just run with the technology and hope for the best. But of course, if you just do that and you just hope for the best, you may end up with the wrong technology. So the question is, how do you find the right sweet spot for you? And again, that will be dictated by what are your priorities in terms of your policy objectives. In the UK, the current government has said our priority, because of the difficult situation in which we find ourselves now outside the EU, but to the extent that this could be an advantage, we want to ensure that innovation is the priority. And therefore, we're not going to go as far as being as dogmatic as the EU. We still want to regulate AI, and we still think that there are some principles that should be applied. But let's be a little bit more pragmatic in the way we approach it. And that is the way in which, again, if there is a new government later this year, may also progress this way of thinking. So it may end up being a little bit closer to the EU than we think what we're seeing today, or not. It may be less because the progress and technological progress is seen as the absolute priority, and the government of the day is prepared to take a risk. That is a policy decision. But I guess every genuine government will try to make the best policy decisions based on what they're thinking.
Yeah, but I mean, we don't have to look that far. Just look at like banking laws. There's a reason why a lot of companies want to establish themselves in the Grand Caymans or Bermuda or any of these, or Panama, like any of the countries that say, hey, we're going to create a regulatory environment that's going to be much easier for you to do business in our country versus anywhere else. Why is the same not going to happen with respect to AI?
Because I think ultimately you need to approach this in a, I guess, responsible way. When you look at business and when you look at success and prosperity, you also need to look at this from the point of view, okay, this has to be successful today, next year, the following year, a decade later. How do we ensure that this is sustainable? How do we ensure that this business has a future? And I think those considerations, and I think we see that with our clients, are very, very important in how they approach compliance. And again, everyone wants to benefit from the best of all possible worlds where you are compliant and you are responsible, but still you are able to develop and use progressive technology. And I think our role, and many of the professionals that we work with will be, their role will be to ensure that they find that sort of, again, sweet spot where you are complying with this very complex law, but interpreting it in a way that is still supportive of what a business is trying to do. And I think ultimately, digital regulation and the ability to advise in this area is all about that, about ensuring that, again, one is compliant, but is also able to benefit from the objectives of that business or the objectives of the technology.
Mm-hmm. So maybe the last question is following on exactly that. I think many people are asking us today, what do I do, right? What this, there's a lot of pages here. This, I don't quite appreciate how this is going to impact me. How is it going to affect my organization? Is there things I need to do now? Are there things I need to do in 3 years? Are there things I need to do in 6 months? I don't know. What do we do?
Okay. So first of all, don't start learning the numbers of the articles because those are going to change once they get published. But anyway, the content is there. And this step number one is to really assess, as I was saying earlier, the degree of applicability of the AI Act to your particular case or your particular use cases. And that involves having some kind of AI inventory where the organization looks at what AI is either being developed or being used. And then the lawyers are able to look at each of those systems or models and apply the law. Step number one. Step number two is to then say, okay, bearing in mind the obligations that apply, which ones are the priority obligations that we need to make sure we put policy in place or a process in place, or we speak with the development team to ensure that they understand what technical documentation. So there will be priorities for compliance that will follow from the assessment. And then, like everything else that is complex, you need to have some kind of program or project plan that once you know what obligations apply to you and what your priorities are, you set out with a time frame how to ensure compliance. Because in terms of time frame, the first sort of set of obligations, that is the prohibited systems, will not be lawful in Europe within 6 months of the law being published. 20 days and 6 months. Then you have another period of about a year for the global for the general purpose AI systems to be compliant, and then a further period of 2 years for the rest of the obligations. So you need to bear in mind the timings to ensure that you are approaching compliance in that particular fashion, to ensure that you deal with the top priorities first.
You and I and many of our other teammates here and many of our clients probably remember what it looked like between 2016 and 2018. 2016, the publication, adoption of GDPR, 2018, the effectiveness of that. A lot of work between those periods. Is that what we're looking at right now?
Yeah, considering that in 2016, we already had 20 years of European data protection law as the basis for the GDPR. So we didn't need to learn the law. Now we need to learn the law, which is new and is far more complex. So I think the complexities are going to be greater in terms of the sort of the landscape you're describing, but the process is going to be very similar. It's going to be very labor intensive, both in terms of understanding the requirements under the law and then deciding what to do about it.
Yeah. And as you know, many of our clients just don't operate within the EU, don't operate just in the United States, just don't operate in any one jurisdiction. Instead, they are subject to the laws of the EU, the laws of the United States, the laws of everywhere else that they go. And thus they are trying to bring harmony and consistency in laws that are not necessarily designed to be harmonized with others or to even be consistent with others. So the challenge, maybe, or the opportunity, depending on how you want to look at it, is to think about the EU AI Act, not necessarily as an EU AI Act compliance obligation, but instead to think about in the EU AI Act as a triggering event for you to be able to get your arms around how your organization uses AI to not only comply with the laws of the EU, but to comply with the laws where other issues are going to come up, including in the United States, which obviously has a lot of laws that will apply to AI, much like they apply to any other type of activity.
Yeah, I agree. I think that's a critical part of the thinking process right now. And we started this conversation talking about the effect, what in Europe is called as the Brussels effect, the idea that European law becomes a global standard. The AI Act is meant to up to a point to become the global gold standard for AI regulation. I think the complexities of the AI Act make that quite challenging in itself. And I could imagine that from a global perspective, and having worked with clients for so many years in the area of privacy and how to adopt global privacy programs, if you applied a similar way of thinking in the way you're describing to AI regulation globally, I could imagine that there will be some aspects of the AI Act that will become the global standard, not all of it, but then companies, again, depending on their own level of resources and risk approaches and so on, will prioritize slightly different things and will set the level of compliance in line with their own risk tolerance as well. And it could be that go for a very sort of AI Act light approach. Others are more prepared to comply with the AI in a fuller way. But we will see that. But I think it is really, really important to finish this discussion by understanding that, of course, AI is global, like the internet itself, and therefore, when approaching compliance with regulation, you really need to focus on that global aspect of the law, taking into account not just one piece of legislation, but everything else that applies in the countries in which you operate.
Well, Eduardo, it's a great place to leave it. Very much appreciate your thoughtful approach to these issues. I always feel like every time we have these conversations, I learn a lot. So thank you. I'm sure the audience at IAPP this week are really going to enjoy these remarks. And I hope that the audience on the Data Chronicles did the same.
Thank you very much, Scott.
With that, I'm Scott Loughlin. This is the Data Chronicles, and those were your data points.